This is Dan Kapelovitz. Dan's our lawyer. He's representing us in this appeal to Ninth Circuit in Pasadena. I'll let Dan tell you about the case and all of that.
All right. Well, the case, like John said, it's an appeal from the trial that John did himself, represented himself, and he was convicted of camping in a non-designated area and disobeying an order from a federal employee. And we appealed that on a bunch of different bases. One was that his conviction improperly violated his constitutional right to travel, that he should be free to be able to walk this land, and part of that is being able to go to sleep when you have to. I mean, you can't just walk 24 hours a day. And he just, on that day when he got arrested and the mules were impounded, he was just sleeping, and these rangers woke him up, and you could tell probably better than me what happened, but...
Yeah, we were woken up about 10 o'clock at night. I was asleep, and the mules, one mule had one mule loose, and the other one was secured. And so they, checked our ID and all that, and asked us what we were doing there, and we told them we stopped there for the night to go to sleep. And it was public space, and there weren't any signs that we could see, or from where we entered, there were no signs, and it was not fenced. The fence was down. And so we went in, and we made a place for ourselves for the night to sleep. And
that's another reason why we're appealing, because he had no notice. He just was walking on a path. He had no idea he was on federal land. He had no idea that it was illegal to camp there. And all of a sudden, he's just sleeping, and without even knowing it, he's supposedly committing a federal offense. And also, when they woke him up, it wasn't safe for him and the mules to walk. It was pitch dark.
Yeah, it was dark, and there's laws against with animals. State law, state vehicle code. You're treated just like an automobile, and you're not allowed to be walking around at night without being properly lit. And we weren't, because we don't travel at night. And so they wanted us to get going at 10 o'clock at night, hit the road. We said no. We said for those reasons. It was dangerous, and we were only there for the night. We weren't causing any damage, and we were out of everybody's way. But they refused and said get off or go to jail, so we went to jail.
Yeah, so that's another one of our grounds for appeal, is that he had a necessity defense. He either had to choose between remaining put, going to sleep, or risking his life and the life and limbs of the mule, walking through the wilderness in pitch darkness. And as he said, it'd actually be illegal to do that too. And he chose the lesser evil, and that's the test. And so right there, the trial court judge should have ruled in his favor just based on the necessity defense. And then also, we're arguing that Mr. Sears should have had a jury trial. Now, the Supreme Court has held that if the maximum punishment is 6 months, which it was here, that you're not entitled to a jury trial. But even though the Constitution's clear that all criminal trials, you have a right to a jury trial, it's in the regular Constitution and in one of the amendments. And so we just think it's unfair that he doesn't have a jury of peers deciding. And his case, all these cases, these misdemeanor petty offenses in the Code of Federal Regulations, the maximum punishment is 6 months in jail, $5,000 fine, and 5 years formal probation, where he could have had a probation officer search him at any time. He'd have to get permission to leave the district. I mean, luckily he didn't get all that, but it's based on the maximum punishment, and that maximum punishment is way harsher than just merely 6 months in jail, which itself is extremely harsh. And people should have a right to have a jury and not have one judge decide the case.
Is that covered by the vehicle code?
Yeah, California Vehicle Code.
And how do they define that?
Well, but their right to move on the public thoroughfare on city, state, county roads is the same as a vehicle. We're under the same laws as the vehicles are.
Sure, but you weren't operating on city roads when they...
No, we was camped on we were sleeping. But they would have been forcing us out there.
So either you would have to go on the wilderness, it is unsafe, or on the roads, it would be illegal.
Yeah. It would have been illegal to be out there at night. We could have been subject to a citation because when
So
we're traveling.
in jeopardy.
So we just, myself and the Mules, we want to thank Dan for taking this case on.
And I want to thank John for doing what he does. His lifestyle, his way of life is really important.